She stood in the courtroom thinking she'd won. The house, the accounts, even my future earnings. Her lawyer had just finished a triumphant speech. Then the judge slid a single document across the bench. "Counselor, you seem to have overlooked that your client doesn't own the company she's claiming. Her husband does, and he always has." That company was Whitman Industrial, my father's life's work. And for 3 years of marriage, my wife believed it was a failing asset she could discard in the divorce. She had no idea I'd inherited the true, profitable parent corporation a decade before we even met. This is how a hidden clause, a single sheet of paper, and a lifetime of silence became the ultimate trap. My father built two things: a manufacturing empire and a paranoia about protecting it. When he died of a sudden heart attack, his will was a masterpiece of misdirection. The public face, Whitman Industrial Supply, was left to my louder, more charismatic uncle. It was designed to struggle. The real engine, the patent holder and parent company, Whitman Manufacturing Group, was given to me with one condition: tell no one, not even your future wife. So I lived a double life. By day, I was a mid-level project manager at a generic tech firm, a story my wife Claire found comfortably unambitious. By night, through a network of silent partners and a blind trust, I directed the company that quietly licensed proprietary fabrication processes to giants in aerospace and automotive. The profits were staggering, but they flowed into accounts under names that weren't mine, managed by a law firm in Zurich that knew me only by a number. I met Claire at a charity gala. She was vibrant, ambitious, a rising star at her own law firm. She talked about legacy, about building something tangible. I fell for the version of me she saw, a dependable, solid man with simple dreams. Our first year was a blur of love and laughter. She'd complain about her draining corporate cases, and I'd listen, my own secret world screaming behind a calm smile. The first crack appeared over wine one night. She asked about my family. I gave the practice story. Distant, modest means father was a small-time machinist. She squeezed my hand. "It's okay. We'll build our own legacy." Her definition of legacy, I soon learned, was intensely material. It was a house in the right neighborhood, cars that signaled success, vacations documented for envy. My salary couldn't touch it, so carefully I began to let a little wealth seep through. A surprise bonus that covered a down payment, an anonymous inheritance from a distant relative that paid off her student loans. Each time I framed it as lucky breaks. She celebrated, but a subtle shift began. My luck was becoming an expected resource. The pressure point was her father, Richard, a self-made man who'd lost it all in the last recession. He saw me as underperforming, a man who didn't grasp the ruthless drive needed to build and hold wealth. At family dinners, his comments were needles. "Still pushing paper, Daniel," or "Claire, you'll be carrying this one if you want that house in the hills." Claire would defend me, but the embarrassment in her eyes was a slow poison. I wanted to tell her. To show him the financial statements that would obliterate his entire net worth in a single line item. But my father's warning echoed. Trust is the first asset a predator identifies. The predator, it turned out, wasn't an outsider. It was the narrative they built together. Claire's sister, Megan, married a hedge fund analyst. Their conversations became a constant benchmark. I failed. Then 3 years into our marriage, Claire came home furious. Her firm was restructuring. She was safe but paranoid. "I need security, Daniel. Tangible, ironclad assets. Not your potential, not luck." That night, she Googled my family name for the first time. She found Whitman Industrial Supply, the struggling public face. She saw the declining stock price, the layoff headlines. She called me into the room, her face pale. "This is your uncle's company, the Machinist." I nodded, the lie tasting like ash. She didn't see a hidden fortune. She saw a sinking ship, and she was furious I'd never mentioned the family embarrassment. This was the fracture. Her ambition, fueled by her father's disdain, now latched onto a new goal, insulating us from what she saw as my family's failure. She suggested I sue my uncle for mismanagement. I refused. The distance between us grew physical, then legal. She started talking to a colleague who handled high-net-worth divorces. "Just planning," she said, but the questions became specific. Was my name on any family trusts? Did I have any inheritance expectations? I played the part of the wounded, clueless husband. It's all gone, Claire. There's nothing there. Then the discovery request arrived. Her filing for legal separation included a standard demand for full financial disclosure. It also contained a specific, venomous addendum. She was claiming a right to any future interest in Whitman Industrial Supply, citing my emotional connection and family history as a marital asset she helped preserve by supporting me. Her lawyer, a sharp woman named Arden, argued that my silence about the company constituted financial deception and that Claire was entitled to a share of its potential future value. They had no idea they were claiming a piece of a carefully constructed decoy. I met with my Zurich lawyer on an encrypted line. His advice was cold Swiss logic. Comply with the disclosure, reveal your true assets, it will end the matter. But it wouldn't end the matter, it would reveal a lifetime of secrecy. It would make me the liar. And a deeper, colder part of me wanted to see how far she would go. What would she try to take if she truly believed I had nothing? I gave my instructions. We would disclose only the surface life, the tech salary, the joint accounts, the mortgage. We would present a man of modest, transparent means, and we would wait. Her legal strategy became clear within weeks. It was a scorched earth play for moral and financial superiority. She claimed my secretiveness about the failing family business was emotional abuse, grounds for disproportionate settlement. She demanded the house, spousal support based on my earning potential, and a lien on any future inheritance. In mediation, her lawyer Arden presented a valuation from a forensic accountant they'd hired. It was a masterpiece of misunderstanding. They had spent $50,000 to appraise the decal, the hollow, struggling Whitman Industrial Supply. The report concluded it was nearly worthless, but that its intellectual property might have residual value. They were hunting for scraps in an empty cupboard while the feast was in the next room, and they didn't even know the door existed. The turning point was a Thursday. My own lawyer, a quiet man named Ben who knew only what I told him, called me. He sounded uneasy. Daniel, they've submitted a new motion. They're asking the court to compel your uncle to testify. They want to depose him about the company's assets and your potential claim. They're asking for a temporary order granting Claire exclusive use of the house and freezing your personal accounts, citing your unstable financial heritage. They're not just going after what you have. They're building a case that what you might asterisk have is a liability, and she deserves compensation for bearing that risk. I sat in my temporary apartment, the hum of the city a dull roar. They were so confident. They were using the truth of my father's public failure as a weapon to bludgeon me into surrendering my private life. Claire thought she was litigating against a ghost of failure, but she was actually, blindly, constructing her own trap. Every legal filing, every claim on the family business was a thread she was weaving into a net, and I held the only pair of scissors. I called Zurich back. Initiate the retitle, I said. For years, the true parent company's assets had been held in a labyrinth of trusts. It was time to simplify, to consolidate every patent, every royalty stream, every holding under a single, new corporate entity, one with a name that had never appeared in any court document, one owned solely by me. The process would take 60 days. 60 days until the invisible fortress was fully visible, on paper only I would possess. I then did the thing my father warned me never to do. I reached out to my uncle. I met him at a dusty diner far from anyone we knew. He'd grown bitter and tired, playing the patsy in my father's plan. I slid an envelope across the table. Inside was a sum of money that would set his family straight for life. In 2 months, I said, a buyout offer will come for Whitman Industrial Supply. It will be from a shell company. You will accept it. You will be free. He looked at the envelope, then at me, seeing my father's cold eyes in my face. He just nodded. The stage was now set. Claire and her lawyer were racing toward a finish line they had painted themselves. They were about to argue passionately, expensively, in front of a judge, that they deserved a piece of something I had already quietly begun to dismantle and reclaim. The first act of their play was ending in triumph. They were preparing their final arguments, convinced the worthless company was the last buried bone of my identity. They had no idea the mountain they were standing on was hollow. And I had just lit the fuse. The fuse burned through the first legal barrier 2 weeks later. Claire's motion for a temporary freeze on my accounts was granted. On paper, I was now a man under financial house arrest. What she didn't know was that the accounts she froze were just the faucet. She had no idea the reservoir even existed. My surface life tightened. I moved to a cheaper apartment, paid for with a prepaid debit card funded from a source that didn't carry my name. I let my car lease lapse. To the world and to Claire's private investigator who was now tailing me, I was a man crumbling under the pressure. I'd have coffee with my lawyer Ben in public cafes, our conversations a performance of despair for anyone listening. "They're going to take everything, Ben," I'd say, just loud enough. He'd pat my hand, playing his part, while passing me a secure tablet under the table with updates from Zurich. The retitling was 45% complete. Then the deposition of my uncle was scheduled. Claire's lawyer, Arden, was salivating. This was her chance to prove the hidden value of the family business and my deceptive character. I instructed my uncle, via a one-time encrypted message, to play his part. Be bitter, be vague, imply there might be secret patents but that they were lost in corporate chaos. He did it perfectly. In a sterile conference room, he mumbled about old processes and maybe some paperwork in a warehouse. Arden pushed him, but each answer was a dead end wrapped in resentment. She left frustrated, but her forensic accountant's eyes lit up. Dead ends, to them, were places to hide treasure. The real treasure was moving. The new corporate entity, registered in Delaware as Apex Fabrication Holdings, received its final approvals. With a few digital signatures from my Zurich team, every patent, every royalty agreement, every dollar of liquidity silently transferred out of the historical trusts and into Apex. I was now the sole beneficial owner of a company with an annual cash flow of over $12 million. And not a single document in the divorce discovery mentioned it. This is when Claire made her critical mistake. Emboldened by the frozen accounts and the struggling uncle's testimony, she decided to go for the kill shot. Her lawyer filed a revised settlement proposal. It was breathtaking in its audacity. She demanded 90% of the equity in our home, 5 years of spousal support at 80% of my last known salary, and this was the masterpiece: a right of first refusal on any future interest in Whitman Industrial Supply for the sum of $1. The cover letter from Arden was condescendingly generous. "This offer," she wrote, "acknowledges the emotional toll of your family situation and provides Claire with the security she needs to move on, while freeing you from the burden of a failing enterprise." They weren't just asking for my fake inheritance. They were offering to buy it from me for $1. The arrogance was the spark that turned my cold plan into a fire. I called Ben. "We need to schedule the final mediation," I said. "The one before the trial, except the date they propose." He was confused. "Daniel, with this offer on the table, going to mediation is a formality. They'll just posture." I smiled for the first time in months. "Exactly. Let them posture. Let them commit." The mediation was set for a Friday, a day before the 60th and final day of my asset consolidation. The night before, I received the last document from Zurich. The buyout of Whitman Industrial Supply from my uncle was complete. The decoy was now owned by a subsidiary of Apex Fabrication Holdings. I owned the hollow shell and the golden goose. The trap was now structurally complete. All that was left was to spring it. The mediation room was all soft lighting and expensive art, meant to soothe savage egos. Claire arrived with Arden and her father, Richard. He gave me a look of pure triumph. Claire avoided my eyes, her posture one of a victor granting terms. Ben and I sat opposite them. The mediator, a retired judge, began by summarizing Claire's offer. He turned to me. "Mr. Brooks, this is a highly favorable offer for your wife. Given the financial disparities and the uncertain family asset, your counterproposal would need to be significant." I leaned forward, clasping my hands on the table. I have a counter-proposal, I said, my voice calm. But first, I need to correct the record on one key asset, Whitman Industrial Supply. Arden smirked. We're aware of its value, Daniel, or lack thereof. You're aware of the subsidiary, I said, the public-facing entity. You're not aware of the parent company, Whitman Manufacturing Group, or its new holding structure, Apex Fabrication Holdings. The room went still. Richard chuckled. Fantasy companies now, Daniel, this is pathetic. I opened my briefcase and slid a single sheet of paper across the table. It was the first page of the Apex corporate registration, showing my name as the sole member. This is a Delaware filing from 3 days ago. Apex is the sole owner of Whitman Manufacturing Group, which holds 17 active patents in advanced metallurgy. It is also, as of yesterday, the sole owner of Whitman Industrial Supply. I slid another page, the buyout agreement. The company you just valued at $0 and offered to buy from me for $1. I now own it outright, and it licenses its technology from the parent company I also own. Arden's face lost its color. She snatched the papers, her eyes scanning. Claire stared at me, confusion turning to dawning horror. What is this? She whispered. This is the disclosure you asked for, I said. The complete financial picture. Apex has a net cash flow of approximately $12 million per year. It has no debt. It is my separate property, inherited and maintained without commingling. Your forensic accountant is welcome to audit the last decade of its records, which my Zurich counsel will provide under a strict confidentiality order. Richard stood up, his chair screeching. This is fraud, you hid this. Judge, he hid assets. The mediator held up a hand, his eyes locked on me, then on the documents. Mr. Brooks, if this is verified, you understand the court will take a very dim view of non-disclosure. With respect, I said, I have disclosed today, before the trial, and these assets are not marital property. They were inherited prior to the marriage and kept separate. My wife's own legal theory confirms this. She argued my interest in the Asterisk family business was a premarital asset. She was just wrong about which business. The silence was volcanic. Arden was frantically typing on her phone, no doubt to her forensic accountant. Claire looked at her father, then at her lawyer, the foundation of her reality cracking. They had built a castle on a lie, and I had just handed them the surveyor's report showing it was built on quicksand. I stood up. My counterproposal is simple. We dismiss all claims with prejudice. You withdraw the motion for spousal support and the claim on the house. We split the joint assets 50-50, the actual joint assets, which amount to about $80,000. You keep the jewelry you already have, and we go our separate ways. Claire found her voice sharp and shrill. You lied to me. For our entire marriage, you let me think. I cut her off, my tone dropping to ice. I let you think what you wanted to think. You saw a modest man and thought him beneath you. You saw a struggling family business and thought it a liability. Your greed and your father's contempt did the rest. You didn't want a partner, Claire. You wanted a resource, and you tried to liquidate the wrong one. The mediator adjourned the session, stating that given the new information, the process needed to pause. As we left, Claire grabbed my arm in the hallway. Her eyes were wide, pleading now. Daniel, wait. We can work with this. This changes everything. We can be a team, a real power couple. I looked at her hand on my arm, then back at her face. The shift from victor to supplicant was complete. The time for being a team, I said quietly, removing her hand, was before you hired a forensic accountant to dissect a life you thought was worthless. The mediation is over. The next time we meet, it will be in court, and I will be asking the judge to make you pay my legal fees for this charade. I walked away, leaving them in a stunned huddle, but as I drove home, I knew this wasn't the end. I had revealed the mountain. Now I had to prepare for the avalanche. People like Richard, faced with the obliteration of their worldview, don't retreat. They attack more desperately, and I had just shown them the size of the prize they had missed. The real battle was about to begin, and the courtroom would just be the opening salvo. The attack came not from Claire, but from her father. Richard couldn't process losing, so he reframed the win as a crime. 3 days after the mediation, my lawyer Ben called, his voice tight. They've filed an emergency motion with the court. They're alleging fraudulent concealment of assets and are petitioning for an immediate seizure of all Apex holdings. They've also named you in a separate civil suit for intentional infliction of emotional distress. It was a scattergun strategy designed to overwhelm and intimidate. The emotional distress claim was laughable. A photo of Claire looking tearful at a cafe was Exhibit A, but the fraud allegation was the real weapon. If they could convince a judge I had actively hidden assets to deceive the court, not just my wife, the penalties could be catastrophic. They were no longer fighting for a share. They were trying to burn the entire empire down. My Zurich team was calm. Swiss law doesn't recognize foreign seizure orders for assets held in their structures without a years-long legal fight. But the motion was a public filing. It meant my secret was now a matter of public record, a beacon for every financial vulture and tabloid journalist. Richard had decided if he couldn't have it, he'd shine a spotlight on it and let the heat destroy me. Then the first real consequence hit. An email from the licensing department at Kronos Aerospace, my biggest client. Due to the potential instability highlighted in recent legal filings, we are placing our royalty agreement under review pending resolution. $1.2 million a year in jeopardy. Richard had found a pressure point I hadn't armored, my business's reputation. I couldn't fight this from the shadows anymore. I called a war council. My lawyer Ben, my lead Zurich attorney on a secure video line, and a new player, a grizzled crisis PR consultant named Mara who specialized in keeping wealthy ghosts out of the headlines. You have two problems, Mara said, lighting a cigarette on screen. The legal problem, which is noise, and the narrative problem, which is cancer. Right now the story is, secretive rich man lies to humble wife. We need to flip it. The plan was aggressive. We would not just defend. We would go on the offensive. First, we filed a motion to dismiss the fraud claim, attaching every communication where Claire's own lawyer referenced the failing family business as a separate premarital asset. Our argument was simple. They knew about the business, they just valued it wrong. Their error is not my fraud. Second, and this was Mara's masterpiece, we would craft the counter-narrative. We needed a villain the public would understand better than a secretive heir. We needed Richard. I hired a discreet investigator. Within 72 hours, he delivered a dossier. Richard's failed business wasn't just a victim of the recession. It failed because of embezzlement. A quiet settlement with his partners, no criminal charges, but the records were there in a dusty county file. He had a history of seeing other people's companies as piggy banks. The third move was the most dangerous. I instructed my Zurich team to prepare a full, audited financial history of the inheritance from my father's death to the present. We would offer it to the court under seal. This was the ultimate gamble. It would prove the money was never marital, but it would also expose every financial move I'd ever made to judicial scrutiny. One mistake, one commingled dollar, and the whole structure could be deemed marital property. The hearing on the fraud motion was a circus. The courtroom was packed. Richard had tipped off the press. Cameras flashed as I walked in. Claire sat with Arden, her face a mask of composed anguish. Richard glared from the gallery. Their argument was theatrical. Arden painted me as a Bond villain, weaving a web of offshore lies to impoverish my loving wife. She presented the Apex documents as proof of a sinister scheme. Then my lawyer Ben stood. He was quiet, methodical. He walked the judge through Claire's own settlement offer, highlighting the line about the failing family business. He showed the forensic report they commissioned, which only looked at the subsidiary. Your Honor, they didn't fail to find the assets. They failed to look. They saw a single tree and declared the forest worthless. That is not fraud. That is professional malpractice. The judge, a weary-looking woman in her 60s, peered over her glasses. She asked Arden a simple question. Did your forensic accountant ask about parent companies or holding structures? Arden hesitated. The initial scope was Whitman Industrial Supply, Your Honor. The judge's frown deepened. The initial scope. She turned to me. Mr. Brooks, you will provide the full financial history to the court's appointed accountant, but the motion for asset seizure is denied. This appears to be a dispute over valuation, not concealment. It was a tactical victory, but not a knockout. The door was still open for them to claim a share if the audit showed any commingling, and the public narrative was still messy. As we left, Richard cornered me in the hallway, his face purple with rage. You think you're smart? You're a ghost in a machine. I'll dismantle it bolt by bolt. I know people. That threat was the pivot. It wasn't legal anymore. It was personal and it was dirty. 2 days later, the investigator called. You said to watch Richard. He just met with a guy named Vince Corelli at a diner off the interstate. I knew that name. Corelli was a former union enforcer with a sheet for intimidation, now running a private security firm. Richard wasn't planning another motion. He was planning a visit. This changed everything. The battle was no longer in the courtroom. It was in the shadows. I had to assume my physical assets. The new apartment, a small warehouse where I stored some old family paperwork, were targets. I moved to a hotel. I had the warehouse contents digitally scanned and then moved to a secure facility. I also did something I never thought I would. I called my uncle. Remember the stories Dad told about the strike in '87, the men he hired to protect the plant? There was a long silence. Yeah, I have a number, he said. But here's the thing about desperation. It makes you sloppy. While Richard was playing gangster, Claire, under the pressure of the collapsing narrative, made her final, fatal error. She tried to go around the law entirely. She used her old firm login to access a confidential legal database. She was searching for my Zurich lawyer's name, for any disciplinary records, any vulnerabilities. She didn't find any, but the firm's IT security flagged the unauthorized access from her home IP address. A breach of client confidentiality protocols. They suspended her login and launched an internal review. Mara, my PR consultant, had a contact at the firm. She got a whisper of the incident. This was no longer about money or divorce. This was about professional annihilation. Claire was putting her entire career on the line for a grift that had already failed, and in doing so, she handed me the weapon to end it all. I sat in the hotel room, the city lights blinking below. I had the dossier on Richard's past fraud. I had the evidence of Claire's ethical breach. I had the clean audit trail from Zurich on its way. And I had a man named Corelli possibly planning to smash up a warehouse. The pieces were all on the board, chaotic and dangerous. It was time to stop playing defense. It was time to arrange every damaging piece into a single, undeniable story and present it not to a judge, but to the one person who could make it all stop with a single signature. The final play wasn't a legal argument. It was a forced surrender, and I knew exactly how to deliver the terms. I didn't send the package to Claire or to her lawyer. I sent it to the one person whose self-interest outweighed their rage, the senior partner at Claire's law firm. The envelope contained a concise summary, the evidence of Claire's unauthorized database search, the dossier on Richard's past embezzlement settlement, and a note. Your associate is about to make your firm liable for malicious litigation. I will file this with the court and the state bar in 48 hours. You can stop her. It took 18 hours. Claire called me, her voice hollow, stripped of all its previous fury. My firm is withdrawing from my case. They've placed me on administrative leave. What did you do? I told her to have her new lawyer, if she could find one, contact mine. The withdrawal of her high-powered legal team was the first domino. The second fell when the court-appointed accountant completed his review of the Zurich audit. His report was a dry, 15-page document that concluded with a single devastating line. No commingling of separate and marital assets was found. The financial history is clear and consistent. With that report, the fraud allegation evaporated. The only motion left before the court was the original divorce settlement, but the landscape had been atomized. Claire had no lawyer. Her father was suddenly silent, likely warned by his own counsel that discovery into his past could be reopened. The public narrative, guided by Mara's quiet press contacts, had shifted. The story was now about an overreaching gold digger and her corrupt father trying to steal a man's inheritance. The judge scheduled a final hearing to resolve the matter. The morning of the hearing, I put on a simple gray suit, no tie, the uniform of the reasonable man. Ben met me outside the courtroom. They've filed nothing new. They're proceeding pro se. She's representing herself. That was the final, stunning collapse. Claire walked in alone, clutching a notepad. Her father was conspicuously absent. She looked small, surrounded by the empty space where her legal team should have been. The judge took the bench, her expression unreadable. She acknowledged the accountant's report for the record. She then turned to Claire. "Ms. Whitman, you are representing yourself today. What is your position on the division of assets?" Claire stood, her voice trembling. "Your Honor, I believe I am still entitled to spousal support and to a share of the business. He deceived me." The judge waited a moment, then opened a file. "The court finds that the business assets are separate property, clearly traced. As for spousal support, you are a licensed attorney currently employed, albeit on leave. Your earning capacity is substantial. The motion for support is denied." She made a note. "We are left with the marital home and joint accounts. Mr. Brooks has offered a 50-50 split. Do you accept this?" Claire's composure broke. "It's not fair. He lived a lie. That house, our life, it was all funded by that secret. I deserve more for what he put me through." The judge closed the file and looked at her, not unkindly but with finality. "Ms. Whitman, you are an officer of the court. You pursued an asset you believed to be valueless with remarkable aggression. You now discover it was valuable. That is not fraud. That is a tragic error in judgment. The offer is more than fair. I will sign the decree reflecting a 50-50 division of joint marital assets only." Case dismissed. It was over. The gavel fell. The legal war was won. But as I stood there, watching Claire dissolve into silent tears at the counsel table, I felt no triumph, only a vast, empty silence. The victory was complete and it tasted like dust. The aftermath was a quiet unraveling. Claire was terminated from her firm 2 weeks later. The state bar opened an inquiry into her conduct. Richard, facing the exposure of his own history, sold his remaining rental property and moved to another state. The public story faded, replaced by the next scandal. My company, Apex, stabilized. The Kronos Aerospace contract was renewed after I personally flew to meet their board and explained the situation as a frivolous family dispute. My life was my own again. But the final piece of revenge, the one that would leave a scar, wasn't about taking more. It was about giving back. I liquidated the hollow shell of Whitman Industrial Supply. I took the proceeds, every dollar, and created a scholarship fund in my father's name at the local technical college where he'd learned his trade. The announcement was a small press release. It listed the fund's purpose: to help students pursuing manufacturing engineering. The founding donation was listed as being made in memory of Robert Brooks, from his son. I knew Claire would see it. It was the ultimate rebuke. The company she tried to claim, the symbol of the wealth she coveted, was gone. In its place was a monument to my father's real legacy, not the money but the craft, and it was forever out of her reach. 1 year to the day after the divorce was finalized, I sat in the study of a new home, one I had bought openly, with my name on the deed for anyone to see. My lawyer Ben, now a friend, handed me a final piece of paper. It was a closing statement. All accounts settled. He smiled. "You know, in all my years, I've never seen a trap sprung so perfectly. They walked right into it." I looked at the document. The numbers were just numbers. "It wasn't a trap I built, Ben," I said. "My father built the lock. They just insisted on picking it." The phone rang later that evening. An unknown number. I almost didn't answer. It was Claire. Her voice was flat, drained of everything. "I saw the scholarship announcement." A long pause. "That was cruel." "No," I said, my voice calm. "Cruel would have been burying you in lawsuits until you were bankrupt. Cruel would have been sending the dossier on your father to his golf buddies. I just returned the money to where it belonged. You tried to own my father's legacy. Now it owns a future for people he would have actually respected. She hung up. I never heard from her again. The silence that followed was different this time. It wasn't the silence of secrecy or waiting. It was the silence of a battle that had ended, leaving behind a landscape forever changed. I had won back my name, my company, my truth. But the cost was the man I used to be, the one who believed love could exist without a prenuptial agreement on the soul. That man was gone. In his place was an owner of everything. So what is the real cost of a secret? In the cold language of the law, the case was clear. Separate property, fully disclosed, no commingling. A clean, technical victory. But in the language of a life, the verdict is more complicated. The law sees assets and liabilities, separate and marital, concealed or disclosed. It operates on facts, but human relationships operate on trust, which is a story we tell each other. I told a story of being a simple man. Claire told a story of building a legacy. Both stories were fictions that collapsed under the weight of a truth no one was ready to hear. This is why these cases are so brutal and so compelling. They're not just about money. They're about the moment the narrative shatters, the moment the person you shared a bed with becomes a legal adversary analyzing your deepest vulnerabilities for profit. The system, for all its flaws, is designed to find the factual truth, but it can never adjudicate the broken trust. It can only divide the rubble. My father's paranoia protected his fortune, but it built a wall that made a real marriage impossible. Claire's ambition and her father's bitterness turned my privacy into a conspiracy. In the end, the court saw a man defending his inheritance, but I was also a man who had weaponized his own life against his wife. There is no clean win in that. The lingering question isn't who was right or wrong. The law decided that. The question is, was it worth it? To live a double life to protect an asset, to weaponize that life when threatened. The inheritance is intact. The legacy is secure. But the cost was the belief that love could exist without a vault. Some might say I traded a human heart for a corporate shell, and they wouldn't be entirely wrong. These stories fascinate us because they live in the extreme, but they speak to a universal fear. The fear that we don't truly know the person next to us. The fear that our trust is a weakness waiting to be exploited. They show us the nuclear option, where every secret is a landmine and every legal filing is a declaration of war. In the quiet after the battle, you're left with what you fought for. For me, it was a quiet house, a company that runs itself, and a scholarship fund that does some good. It's a life of ownership and of profound solitude. The power dynamic was inverted, the assets secured, but the victory party is a party of one. The law calls it a judgment. History might call it a cautionary tale. I just call it the life that remains after the dust of a shattered truth settles. It is what it is. If these stories of hidden truths and sudden reveals pull you in, there's always another one waiting. Hit subscribe and we'll uncover the next one together. Thanks for watching.